Well, first of all, thank you for coming. I'm going to have to project. And forgive me if I keep drinking water, because I just had a class and I'm going to one afterwards. So I have to keep my voice relatively intact. A class about the corporation would seem to be something of an anomaly on a day that's devoted, in the main, if you look at most of the presentations, to civil rights and race and social justice or social injustice. Among subjects like the working poor, the disabled, or the racially discriminated, you would think then that the corporation looks like something like this kind of clueless blue blood who's chattering on a headset, and he boards the wrong flight and registers at the wrong convention. But that's precisely why I've chosen to invite the corporation into what seems to be a gathering for the subaltern and the oppressed. Because sometimes it seems to me that the plainest facts are the most difficult ones to see. And one of the plainest facts is that the corporation, which is the institutional centerpiece of modern capitalism, is very simply the pivotal economic and political actor of our time. Love it. I'm hating this. I'm going to close the door. Doesn't get back in. Love it, hate it, or most certainly overwork for it, the business corporation is the Leviathan of the 21st century. In fact, I think that if that famous frontispiece of Hobbes' Leviathan were updated, the figure would sport a suit and a tie. It would wield not a sword and a scepter, but a cell phone and a BlackBerry. When this 800-pound gorilla is recognized in the room, there's debate over how to treat it. To its admirers, and I'm assuming that there must be some admirers of the business corporation in here, the business corporation mobilizes all the technological and scientific and organizational prowess that provides us with our food, our clothing, our shelter, and what seems to be the apparently inexhaustible supply of commodities that we have. In this view, the corporation simply humbly serves the sovereign consumer in the unregulated market. And so the corporation represents the triumph not simply of capitalism, but also of democracy. Now, to its detractors, the corporation is this huge and unacknowledged tyranny. It's a gargantua who wastes and despoils the planet's ecology. It's a globe-encircling syndicate of avarice and exploitation. Well, I just want to say that corporations are people too. Quite literally. That's not a smirking irony. It is on a bumper sticker. It is legal reality. Or more precisely, it's a legal fiction whose enactment has all sorts of material and cultural and political implications. In American law, the corporation is a person. Wal-Mart, Microsoft, and Halliburton stand alongside you and me before the blindfolded lady holding the scales. Now, there's a really complicated and fascinating history behind this, some of which I'm only going to sketch today, but it remains a fact which I think with which Americans have yet to even understand, let alone confront. Now, what I want to do is relate a brief history of the legal fiction of corporate personhood and discuss some of the real weirdness, let alone injustice, that stems from this, and suggest some alternatives to the current legal and political structure of corporate governance. And in some sense, what I want to argue is ironic, given the theme of these talks today, which is that the achievement of social justice in this case requires that we limit rights, that we curtail rights, even take them away from certain entities. Now, to set the stage, I want to start with this really unlikely but illuminating source, and that is medieval political theory. In order to understand the modern corporation, you have to understand something about medieval political theory. Now, there's this great medievalist named Ernest Kantorowicz, and he wrote a book entitled The King's Two Bodies. All right. Now, medieval kingship rested on not just swords, but also metaphysics. Any kind of political rule, folks, rests on a metaphysic of some kind. You may not be aware of it, but you're all metaphysicians in some sense. Now, the medieval king had two bodies. One was called the body natural, all right? And that was the monarch's actual physical body, right? The body that was liable to infirmity and death. But there was also the medieval king's body politic. All right. Now that consisted of policy and government. And that couldn't therefore be subject to this kind of natural maladies of sickness and death. In short, medieval kingship was a legal fiction. It was a legal political fiction. And it was also, as Kantorowicz recognized, a religious fiction as well. Kantorowicz wrote, in fact, quote, "This man-made irreality, indeed that strange construction of a human mind which finally becomes slave to its own fictions, we are normally more ready to find in the religious sphere than in the allegedly sober and realistic realms of law." Now, to most of us, medieval kingship is pretty musty and it's quaint and it doesn't have anything to do with us. But it's worth recalling that it once had the full force of law. And I think we can see a very similar irreality in the allegedly more sober and supposedly secular realms of economics and corporate law. Now, the rise of the modern corporation certainly resulted from business ingenuity and technological change and class struggle, but it also resulted from the legal imagination of capitalism. And because legal notions of responsibility are rooted in some kind of a notion of moral agency, in order for you to be held responsible for something, there has to be some sort of a conception of what it means to be an agent, of what it means to be able to do something. We can say that the creation of the modern corporation is a study in the metaphysics of personality. In order for us to understand our notions of the corporation, we have to understand what a person is, because if it's a person under law, we have to know what a person is. And that question, what is a person, was actually triggered by the Industrial Revolution in the United States in the 19th century. And here's why. If you go back in American history to the early 19th century, all right, corporations were clearly understood to be public institutions. You know, we talk about private enterprise in the United States. A corporation, by definition, is not private enterprise. All right? It is collectively owned. It's owned by a variety of people, which makes it, strangely enough, a socialist enterprise. I'll come back to that. And they were regulated and created by state legislatures. We also tend to forget this. A corporation is a creation of a public body, democratically elected. The implications of that I'm going to come back to at the end of this talk. Corporations in the early 19th century were created by state legislative charters, and they specified their objectives and their dates of termination. When you created a corporation in, say, 1834, you specified the date on which that corporation began and the date on which it would end. There would be no more Microsoft after such date. As an 1832 treatise on corporate law put it, quote, "The design of the corporation is to provide for some good that is useful to the public," end quote. A corporation, according to the Pennsylvania State Legislature in 1834, remember that, Pennsylvania State Legislature, 1834, says, a corporation is, quote, "just what the Incorporation Act makes it." Quote, "It is the creature of the law," the Declaration continued, "and may be molded to any shape or for any purpose the legislature may deem most conducive for the common good. Now note well, that's the 1834 Pennsylvania State Legislature, hardly a bastion of socialists and anarchists. Corporations were strictly limited, in part because of the nature of American capitalism in the early 19th century. And it's proprietary capitalism, all right, not corporate capitalism. In the early 19th century, it is proprietary. Now there, if you thought about capitalism in the early 19th century, you're talking basically about the male freeholder, okay, the male artisan, the male farmer who owns his workshop or his farm, okay, and he performs both mental and manual labor. Now that's important to understand here. An artisan or a farmer combines mental and manual labor. The prying apart of these two things is going to be central to the story. Now for males, and understand this, being a man in the early 19th century was bound up with owning property. To be a man in 1834, you had to own property. And also, I might add, to be really white in the early 19th century, you had to own property. Property was considered to be the basis of moral agency. You couldn't do anything unless you had property. So hence, white males were the center of legal notions of responsibility in the early 19th century. Now that conception of property and that conception of responsibility and personhood is what actually, in a strange way, underlies our notions of civil rights. In other words, the notion of civil rights itself is bound up with bourgeois notions of self-ownership and property, which is a fact that a lot of my friends on the left don't like to think about. So how did we get from the corporation as a legally created entity with strictly defined public goals and limitations to the corporation as a legal entity endowed with personhood and mandated only to enlarge shareholder equity? Well, part of the story revolves around the history of how that old proprietary model of capitalism broke down in the 19th century, especially after the Civil War. Now, in their efforts to increase profits, right, that's what you're supposed to do if you're a capitalist. You are supposed to accumulate and increase profits. Capitalists, and especially merchants, realized that they had to use more advanced technologies, which meant that they had to get more control over their workers. Because in order to introduce this technology, what are you going to have to do? You are going to have to basically destroy old, artisanal, craft ways of life. And so these workers in your factories are going to resist you if you start introducing these technologies, because to the extent that I introduce technology, I don't need you. You're going to resist me. The factory system, I think we have to remember, is not about the stuff. It's not about this building called a factory. The factory system is about disciplining workers and making their labor methodical, right? If anybody has ever seen, for example, the classic movie by Charlie Chaplin, Modern Times, right? The famous scene where Charlie Chaplin is going through the wheels of the machine, and he's doing things like this, constantly doing this for 14, 15 hours a day, right? That's the kind of thing that is involved with industrialized labor. You mechanize it. You routinize it, all right? But what does that require? You're not going to want anybody who exercises mental labor doing this, because, my God, you're going to get pretty bored after a while doing this. So what you do is you separate mental and manual labor. That's a shotgun divorce. And it creates what we know as the working class. All right? The working class does the manual labor. They stuff the machines, they tend the machines, whereas the mental labor is now performed by professionals and managers. In other words, people like you. People who you are studying to be. The modern university system, by the way, is a result of this. Because you're all being trained to be professionals or managers, or most of you are being trained to be professionals and managers. In other words, to do the mental labor. Now notice already we're starting to destroy those old proprietary notions about work and about responsibility. But that's only a part of the story. In order to get the capital that's required for investment in this technology, capitalists had to go outside the family circle. Because let's remember, in the early 19th century, most capitalist enterprises are either family businesses or they are limited partnerships. All right? But this meant, in order for them to get more capital and to go outside the family circle, you had to offer that thing called limited liability to investors and shareholders. So what do you have to do then? You have to separate ownership from daily control of the enterprise. How many of you have stock? How many of your parents own stock? If your parents own oil stock, the closest they ever come to oil is when they fill up their gas tanks. That's important because it implies that the people who own the business don't know a damn thing about it otherwise. All right? In other words, the separation of ownership and control is analogous to the separation of mental and manual labor. Notice what's going on here. Certain things are now being torn apart. All right? Now this only further completely discombobulates the old proprietary order. For example, and some of my students have heard this question before, so be quiet. Who owns the car that rolls off the assembly line of General Motors? It's not the workers. It's not the engineers. It's not the executives. It's not even the shareholders individually. Who owns it? GM. In other words, General Motors owns the car, not a physical entity at all. So much for materialism as the greatest evil of capitalism. A legal fiction owns those cars. That's weird. But I'm getting a little ahead of the story. The corporation was a legal as well as an economic entity. And so we have to look briefly at this whole ensemble of federal and state court decisions that comprised what really, in a sense, amounts to a Copernican revolution in business law. Now, recall that the center of that old capitalist universe had been the male proprietor, right, holding his plow or his hammer in his thick, calloused hands, right? Now, by the 1870s and 1880s, this very simply was not the way most industrial labor was being performed. The emerging conditions of corporate capitalism were placing an emphasis on the interdependence of people, not the independence of people. Now, a lot of judges and economists and business journalists saw this reality. And they were arguing basically that we had to change the nature of the way that we thought about capitalism. In other words, they were talking about what we would call the new economy of the late 19th century. And so in a series of court decisions that stretched over the 1880s to about the 1920s, federal and state courts, but especially the Supreme Court, extended to corporations the legal status of a person with the meaning of the 5th and the 14th Amendments. At first to their stockholders and then to the corporation itself as this entity, the Supreme Court bestowed the rights and privileges it had originally ascribed to proprietors and protected these new entities against deprivation of life, liberty, and property without due process of law. In effect, to the limited liability of the stockholder was added the limited liability of the corporation in the face of the power of government. Now, the important cases here are, first of all, the Santa Clara case of 1886, which defined the corporation as a person. Right? The Supreme Court in the Santa Clara case said, basically, the corporation has rights just like you or me, flesh and blood people. And the other bookend is a 1919 Michigan Supreme Court case entitled Dodge versus Ford Motor Company, which set the standard of shareholder primacy, right, as the criterion of corporate performance. Seeking profits and increasing shareholder equity is a legal mandate under American law. All right? Now, I'm going to come back in a moment to why that makes so much nonsense of a lot of people who think that you can have socially responsible corporations. You can't, under the law, because increasing shareholder equity is legally mandated in American law. Now, this process wasn't completely straightforward. All right? In 1906, the Supreme Court ruled in Hale versus Hinkle that the Fourth Amendment protection against unreasonable searches and seizures applied to corporations, but that the Fifth Amendment privilege against self-incrimination didn't. In 1950, in U.S., I love this one, U.S. versus Morton Salt. Okay, you know, the one that has the girl with the umbrella, okay, the Morton Salt canister. U.S. versus Morton Salt. The power of the government was brought against that poor girl. U.S. versus Morton Salt. The court ruled that corporations can claim no equality with individuals about privacy because they possess, quote, public attributes that have a collective impact on society. In other words, you've got a pretty incoherent mismatch of legal decisions about what exactly constitutes the legal nature of the corporation. But since the 1960s, the Supremes have pretty much given up on theorizing about corporate personhood and have pretty much been giving ever more generous protections to corporate persons under the law. Now, legal theorists and philosophers were very clear that the courts were creating really unprecedented and strange rights for corporations. There's one corporate theorist who was writing in the Harvard Law Review in 1911, and he said that one, quote, had to pierce the veil of corporate entity in order to see the human beings who are behind the entity. He still conceded that this new kind of entity was simply an association, was not simply an association of shareholders, but, quote, recognized and treated by the law as something distinct from its members. In other words, the corporation's existence as a legal person is an example of what Marx called fetishism, or of what Weber would call enchantment, or of what a theologian might call a doctrine of the church. In fact, the literary critic Kenneth Burke said this in 1937 when he said that the corporation had inherited from the medieval church, quote, the unwieldy mysticism of the corpus mysticum, the mystical body of business. Now, the emergence of this corporate personhood didn't go unchallenged. The legal construction of corporate personality in the late 19th and early 20th centuries took place at the same time that other movements, like labor unions, socialists, anarchists, populists, and progressives, were also attempting to harness the possibilities generated by modern capitalism. And most, if not all of these groups were alarmed by the new ideas of corporate personhood. Socialists and populists in particular noted that this whole edifice of corporate law, which was being constructed, was basically using the old proprietary language to shield corporations from legal and political challenge, and to protect a basically unelected government of capital and management from any sort of dissent. So, but progressives, in other words, by the way, the ancestors of what we would call today modern liberals, the capital P progressives, they saw some of these legal and economic entities, these corporations, as actually steps toward a more humane order. All right? They hoped that this older conception of the corporations as public institutions, right, the one that was talked about in the Pennsylvania legislature, could be revived and applied to a new industrial order. It's useful to be reminded at this point that that corporate personality then defined the terrain of subsequent political and economic life, all the way down to the present. Much of the atrophy of left-wing radicalism in this country can be traced to its inability to deal with the fact of corporate personhood. Notice, for example, the emergence of the modern welfare state as the centerpiece of the liberal tradition, all right, stems from the liberal tradition's acceptance of the corporation, which should belie, by the way, all notions about alleged liberal hostility to business. And much of conservatism, what we call conservatism, evolved into a defense of an institution that violates every traditional proprietary nostrum about ownership and moral responsibility. If you are a genuine conservative, you should hate corporations. Hate them. Moreover, the defense of corporate personhood shaped judicial interpretations of the 14th Amendment in such a way that racial minorities were excluded from the canopy. In 1938, Justice Hugo Black observed that of all the 14th Amendment Supreme Court cases since the Santa Clara decision, so from 1886 to 1938, quote, less than 0.5% invoked it in protection of the Negro race, and more than 50% asked that its benefits be extended to corporations, end quote. So consider some of the things that, as Lewis Carroll might say, are curiouser and curiouser about the modern corporation. Take that legal fiction of shareholder primacy. However generous stockholders can be as individuals, I'm sure they're very nice people, they pet their dogs, they play with their kids, they give informed attention to the arts, and they help out at soup kitchens. However generous they might be as individuals, stockholders are absent, passive, and largely unproductive body of speculators whose sole activity is the extraction of wealth. Shareholders do not provide most of the capital for modern corporations. That is one of the best hidden secrets in the business school. Most capital for modern corporations comes from retained earnings, not shareholders. So don't believe a word when any shareholder might say to you, I am providing capital for the enterprise of this company. You're not. You're not. In the world of flesh and blood and stagnant wages, the corporation is a community of persons who make things and meet human needs. The fiction, therefore, of corporate personhood is as pernicious as it is breathtaking. Legal theorists have noticed this themselves. I'll quote an indispensable 1967 book, Legal Fictions, right? If you go to law school and you study corporate law, you will read this book. Legal Fictions. Lon Fuller states, quote, the strangeness and boldness of the legal fiction has tended to stifle layman's criticisms. That's not a Marxist. That's not an anarchist. That is a law professor. John Lubin of the Wharton School. The Wharton School, again, not a haven of anarchists. John Lubin of the Wharton School observed that, quote, it is unrealistic to manage the affairs of a company as specified in most legal statutes, for the board simply cannot perform the functions required. It is just as unrealistic to expect the board to be a policy-making body and to really participate in strategy-making functions, which is a way of saying corporate boards don't mean anything. And speaking legally, the stockholders both own and are the corporation, yet they cannot be held personally responsible for its actions. They own a person, which means they can sell it, which raises curious questions about the meaning of the 13th Amendment, which prohibits involuntary servitude. The status of employees raises similar conundrums. If a corporation can be bought and sold, aren't employees bought and sold? But if the employees are not part of the corporation, which as property is a commodity, while it's also a person, then what exactly is their legal status? It would seem that workers are part of the property. And so when companies cheerfully proclaim in their public relations that, quote, our employees are our greatest assets, you should think about that. Because the smiley face, get past the smiley face and recall that assets are things that are owned. As parts of the property and within the legal framework of the corporation, employees have no due process, no right to privacy, no protections against unreasonable search and seizure, no free speech, a right to which, I might add, is protected for corporations. Police need a court order to do what corporations are allowed to do every day. Install cameras, monitor computers, tape conversations, examine your urine. According to the American Management Association, again, hardly a cell of reds. According to the American Management Association, 3/4 of major corporations engage in these kinds of employee surveillance. In other words, democracy stops at the lobby entrance. Now, knowing this history and its consequences enable us to see why so many liberal approaches to the corporation are misguided and toothless. Those who argue for socially responsible or soulful corporations are very well intentioned, but their fine intentions run up against two very intractable realities: the way capitalism is, and the statutory mandate that is laid on corporations to pursue profit only. In this case, the road to irrelevance is paved with good intentions. Diversity-based criticisms are equally misplaced. Saying the corporate boards and managerial suites should contain more women and racial minorities is like saying we should have more slaves among the master class. It does nothing to address the real problem, which is the structure of corporate governance itself. Indeed, it even obscures and preserves some of the basic tenets of corporate mythology: that the stockholders are the corporation, that they elect the board, that the board is a vigilant superintendent, and that non-managerial employees deserve their subaltern position. I also have to say that a lot of the criticism that emerges from Catholic social thought is often equally useless in the face of the corporation. So what's to be done? If we wish to recover this traditional conception of the corporation as a public institution directed to a common good, and if we wish to recover democratic self-government in the settings where we work, then we have to recognize that corporate personhood and its associated bundle of rights stand in the way. Thus, we should abolish the legal fiction of corporate personhood, strip corporations of their rights under the law, and even rethink what we mean by corporations and their internal governance. In other words, like any good radical position, mine appeals to tradition, and in this case, to the tradition of American democratic thought. By abolishing corporate personhood and its rights, we can restore something of the old proprietary self-government on a new basis. First, it would be worthwhile to remember that we do have the right to revoke corporate charters. The right to revoke corporate charters is still present in all state constitutions. Tomorrow, you could do it. Tomorrow. State legislatures used to limit corporate existence to a fixed number of years, spell out permissible behavior, and hold owners liable for harms. There have been attempts to do this. In 1998, Loyola law professor Robert Benson and a coalition of public interest organizations petitioned the California State Attorney General to revoke the charter of UNICAL for environmental and human rights abuses. An even more vital governing power is the right to alter corporations themselves. We could, for example, limit or even prohibit the right of corporations like agribusinesses to own farms. But even more, we could relegate shareholder primacy to the dustbin of history. If corporations are public entities created to serve a common good, then shareholder claims are subsidiary to those of the public. And the range of that democratic public has to be extended to include the employees of the corporation itself. Here's where dispelling all this fetishism and enchantment has its greatest political impact. Any rational account of the corporation puts employees and not shareholders at the center. When you call to complain or when you buy a commodity, you are not talking to IBM or to Wal-Mart. You are talking to an embodied, incarnate human being. Yet in the legal and political universe of contemporary corporate governance, employees are almost invisible. When shareholders elect a CEO to govern a corporation, it is not shareholders who are being governed by the CEO. Employees are the ones who have their emails monitored, their phones tapped, and their urine explored. One could, in fact, compare the current wage contract to what was once called, in medieval law, the pactum subjectionis, a pact of subjection by which a people alienated their right to self-government and turned it over to the king. If these contracts are no longer considered legitimate in the political sphere, they should cease to be legitimate in the economic sphere. Even if we remain within the bounds of capitalism, this means that legislatures and courts should bestow on employees a considerable degree of privileges and protections that they are currently denied. And ultimately, I think employee rights can't be safeguarded except by firing the stockholders and giving ownership and control to the workers in the firm. In other words, the legal status of corporations and their employees arguably constitute the most unrecognized and yet urgent civil rights issue of our time. But that's going to force us to rethink, and rethink very hard, the very meaning of persons and rights, and to squarely face the consequences of a century and a half of economic transformation. We still have yet to even understand what's staring us right in the face, let alone address it. The eradication of corporate rights, the creation of a more humane and democratic workplace, is a step toward what King called a beloved community, and that we normally don't think has anything to do with our daily labors. It does. So I'm done. Questions, comments, abuse. Yeah.
Is there a means of connecting the dots between the conception of the corporation as a public institution and holding them accountable to allow things like the various amendment rights that you indicated that they daily violate? I'm just trying to envision what the legal logic might be that would get from point A to point B on that one. Because it doesn't seem that simply denying the corporation the legal status of personhood would all by itself automatically necessitate that particular...
No, they wouldn't. No, you're right. You're right. And you would get, I'm sure that you would get a lot of argument with the position I've taken that in fact, okay, say you do strip a corporation of legal personhood. Mm-hmm. You're right. It doesn't necessarily entail, right, that the whole train of those other changes that I'm advocating. The changes that I'm advocating, the rest of those are, I mean, I'll be honest, they're political and ideological reasons why I would want those. Mm-hmm. The legal, I'm not sure that you would have a legal logic, maybe as much as a philosophical logic, which would be one of democratic self-government. If you are going to say that you have the right to vote for this thing called elected officials, but they are only for this thing called the state, why is that logic not applied to the workplace?
No, or at the very least,
right.
It would seem that we can suggest that there is a reductio ad absurdum with regard
right.
to indentured servitude of the employees.
Right.
I mean, there's certainly a
right.
philosophical logic to get from point A to
right.
point B there. But after hearing your very engaging rap on that history, I'm kind of interested in what to practically do tomorrow. You know?
I would say the one thing you could do tomorrow is, you know, call Robert Benson at Loyola and say, look, I mean, how, for example, did you go about trying to get Unical under some kind of control? I mean, I'm sure that there are all sorts of corporations in Pennsylvania who could be targets for this, and you just kind of settle on one and ask Benson what he decided to do. And again, emphasize that even within the history of the Pennsylvania legislature, and even within the history of Pennsylvania state law, you have precedents to which you could appeal to say, look, I mean, corporations corporations aren't natural entities. We made these things. And in fact, in the early 19th century, when we made them, we specified all kinds of limitations. Why exactly can't we do that now? I mean, I guess I'd also expand on your point about indentured servitude. When you look at the body of corporate, or the body of law that deals with, for example, workers' rights in the United States, it is positively feudal. F-E-U-D-A-L. I mean, not only F-U-T-I-L-E. I mean, it is F-E-U-D-A-L. When you look at the way in which employees are treated, both in terms of corporate settings and in terms of the rights to which the very few meager rights to which they are entitled under the law, it is astonishing. Really astonishing. The stuff that American workers put up with in their workplaces would never be tolerated in Europe. Never be tolerated. The sorts
and due process, especially.
Yeah, it's astonishing. I mean, the kinds of things that employees are expected to give up when they walk into the lobby entrance is mind-boggling. You know, you think that you have rights to free speech and rights to assembly. No, you don't. No, you don't. In fact, if you don't even have to talk about the workplace. I mean, all you have to do is talk about, for example, the relationship of the legal status of free speech in for example, shopping malls. You know, I mean, it's sometimes said that, oh, shopping malls are the last public spaces we have in America. No, they're not. They are mercantile commercial spaces, which means that the merchants and the vendors there have the complete right to tell you you cannot say certain things in those spaces, like have rallies, give speeches, get up on a soapbox and talk about something like you can in Hyde Park in London. No, you can't do that because it is a owned space. They're not public spaces. You don't have public spaces in America anymore. I mean, maybe you have them out on the quad, but that's pretty small area of real estate. So, indentured servants, that's what you're all going to be when you walk out of here. So you're all going to start the revolution tomorrow? Is that my understanding? How many economics or business students do I have in here? None? Wow. I was actually hoping that many would show up. So that, I mean, not to be contentious, but I mean simply to give you guys the bad news. Or the real news. I mean, as the case may be. Yeah. It's really true. Whenever I do teach business students, and I tell them that shareholders, stockholders, do not in fact provide most investment capital for firms, that blows their minds because they usually think, oh, well, you buy stock from a broker, and that must mean that you're giving investment capital for firms. No, you're not. No, you're not. No. You know how much you provide? Maybe 3% of the total capitalization of a typical American firm comes from the sale of common stock. and even preferred stock. I mean, you walk into an economics course. How many of you have had basic economics? Macroeconomics, microeconomics? Okay. You probably hear the myth about, oh, well, stockholders provide the necessary lubricant of money and capital for investment. Well, it's not true. And they'll tell you that down there. They will. That's it. It's going to be a long session, folks. Think of something. My God. Are you simply a completely apathetic group? Doesn't care about your future rights as workers at all? I have to assume that. Let me try this provocation. None of your contending presidential nominees will do anything about this. How's that for a provocation? Which is why you shouldn't vote next November. How's that? Don't vote. Yeah. Okay, I want to object to that. Yes.
We talk about the corporations, the goal of corporations to make profits for the shareholder.
Right.
Legally. But we know that corporations do not just go out and, make as huge profits as they could because of the market.
Right.
How would, what you were talking about, an employee-based company, how would that exactly work as far as profits? If you had an employee-based company,
right,
would they go out and, what would basically stop them from going out and making as much profits as possible?
Nothing.
Okay.
Nothing. I mean, this...
What kind of regulation?
Well, this is why, I mean, it seems to me that when... remember I prefaced that by saying, look, even if you remain within the bounds of capitalism, we assume usually that capitalism, the only form of capitalism that we have is the one that we have right now. Now, even if one advocates the abolition of capitalism, okay, if you talk about employee ownership, talking about employee ownership in itself is not enough, right? Because employee ownership can take place within a variety of different political and economic structures, okay? It's perfectly plausible to think that an employee-owned firm can be as ruthlessly accumulative as any that's owned by shareholders. That's absolutely right. Which means that, in one sense, it would work no differently than a shareholder-owned firm. And the kinds of regulations that you would have would in many ways be very similar to the ones that you have now. I mean, such as the regulatory structure is. I mean, over the last 20 years, it's been pretty much obliterated. But the point is that that's one way of understanding employee ownership. Employee, for example, there was something of a movement which was very robust about a decade and a half ago. It seems to have sort of withered, which was this ESOP movement. It was called Employee Stock Ownership Plans. Okay. Now, usually what tipped me off about how bogus these would be was that these were often offered in companies that were declining. Okay. Usually in sort of Rust Belt industries in the 80s that were going under. And the employees would, sometimes they did well, sometimes they ran the thing into the ground, just like shareholders would, right? So in some sense, it wouldn't matter at all. If you had a different kind of context where, for example, you had employee ownership, but there was more sort of a cooperative sense of how we produce and exchange things, obviously you're going to get a different kind of dynamic and a different kind of regulation. So talking about employee ownership is, I think, only part of what you have to do. You also have to specify the contexts in which these things are going to take place. Right. So, I mean, hearing employee ownership, one might think, okay, Bolshevik. That's state ownership. I mean, not employee ownership. So, but what's important, I think, to me, what's important to me here is that people realize the enormous amount of political power they have if they would simply recognize it. It is there, right? It's not like, oh, we got to go fight for our rights. You have your rights. You just don't exercise them, right? And part of the way that you don't exercise them is not to be told that you have them, right? So that's why you should call Robert Benson tomorrow and, see if you can turn the screws on, I don't know, name a corporation, Wal-Mart, on whose board Hillary Clinton sits. So, the idea that she's a reformer, I mean, give me a break. I'll bash the others too if you want me to. I mean, I don't have any liking for, any of them, so. I don't want to dismiss you so early. Is it in my power to dismiss you? mean, I don't know. I don't know. Wow. Yeah.
In talking about the idea of employee ownership of a corporation, or whatever it would be called,
Yeah.
I can't wrap my head around how you reconcile a group of employees owning the company and still abolishing the idea of the legal fiction, which seems to be one of the primary moves to stop having this kind of subservience to the form of the corporation or something.
Well, one way you could do it is to remember that there were different ways of understanding corporations in the past. I mean, one is, of course, the public interest conception of the 19th century, right? Where, okay, you had the corporation had a legal status, but it was not the legal status of a person. It said, for example, okay, here's an example of what you could do. Employees in firm X are going to be a corporate entity called, firm X, and they're going to start on January 25th, 2008, and their charter will extend until January 25th, 2009. Okay? If the legislature feels that, well, you guys have been upstanding citizens, you've done certain things and you've abided by the law and you've done, you've met certain criteria, we'll extend it. That's fine. Right? Because it's been done democratically, it's been done within the bounds of the public good, and hey, if they want to extend it all the way to eternity, great, okay? What you have now, right, is, corporation goes to Delaware, which is where most firms are incorporated, okay? You go to Delaware and you get incorporated, and man, you can go on and be a corporate bastard for 500 years, and no one will stop you. Because that's the way corporate law structures the chartering of corporations, the incorporation of firms. You could still, corporations are still going to be legal entities of some kind. They're just not going to be persons who sort of, have this life until they die, right? Or literally, eternal life. Eternal life. Wal-Mart is a mystical body. It really is. You thought it was just, cheesy products on stock shelves. It's not. It's a mystical entity. So, or you could think about the Middle Ages. Now here I'm going to be accused of being a medievalist, and I'm not. But you used to have these things called guilds in medieval cities, in medieval towns. Guess what they were called? Corporations. Or, sometimes they were called collegia. Yes, that's the origin of college. And then you would have, the weavers and the carpenters and the blacksmiths and all this organized into these guilds, and their businesses would sometimes be called corporations. Guilds, are also the forerunners of modern unions. So there's a nice case in which you've got the owner, manager, worker linked together in a guild. I think that's an ideal, to be honest with you. Guilds. Modern guilds. Doctors. Can you imagine telling a doctor they should unionize? Guess what? 30% of them are now. Bet you didn't know doctors were in unions. Yeah. No one else? Man, oh man. Well, if there are no other questions, I'll let you go.